bumpers. Show me the best love, bumpers. Who had the best love, bumpers? Who are the best love, bumpers? Ma! Who are the best love? There's a love song, there's a love song. My king, with your arms and bring a love song. I hope you're satisfied now with your love song. One. I would love I would Lord. Everybody let me see you clap those hands. Come on and let me see you clap those hands. Everybody let me see you clap those hands. Come on and let me see you clap those hands. I'll tell you how it. Tell you how it. a shower. You will feel it anywhere you look, and it read like a storybook. I come from when drum used to carry it. We used to carry it when the drum used to carry it. We used to carry it when the drum. We used to carry it. We used to carry it when the drum used to carry it. We used to carry it when Arima had it, Maturita had it, Santa Rosa had it, Donyaruka had it, in Mofa had it, in Sawa had it, Soparia had it, local over, Long Set was the vibes when West people live from Lincoln, John and beat on to head to the playground and good design. Arima and Central, Tobago and Southside. The traffic on insomnia morning down the by West morning. Have cars parking like a garage. Me drinks bottle long like ruler in a cooler and reaching with the mouse to from Canada. Yeah, I did it wrong. We used to carry it. We used to carry it on the ground. We used to carry it. We used to carry it on the flag. We did carry it. We used to carry it on the cooler. We did carry it. We used to carry it when Central had it, Korea had it, Columbia had it, Giving Vidal had it, 500 had it, when Enterprise had it, Nova had it, the full of our downtown it was a safe space. 30,000 people of different background, confusion, PSA ground shaking like an earthquake. But everyone was fine, it was when hot girl wine. We used to see the downtown massive and the uptown massive with no fences to separate. And it was like a rite of passage when your clothes get damaged, shut you start fetching by the gate. Then time did it grow, we used to carry it. We used to carry it up and down, we did carry it. We used to carry it when the flag, we did carry it. We used to carry it when the band, we did carry it. We used to carry it, Marabella had it, and Santa Cruz had it, Pinto had it, Palo Seco had it, and Ramshishet had it, Chola Filet had it, and Maraca had it, and everywhere, hands in the air here now. Hand up in the air, hand up in the air, hands in the air now. Hand up in the air, hand up in the air, hands in the air now. Hand up in the air, hand up in the air, hands in the air now. Hand up in the air, hand up in the air. Gent and the laws of the ghetto did say, make sure nothing else ain't take over sound. Big CEO and management did used to live to make sure that they touch ground. Big flag fluffing all over like wind. Chocolate baby jumping with ice cream. Them time a man drop a tune 2 weeks into carnival and take away everything. Them time did it go, we used to carry it. We used to carry it to the ground, used to carry it. We used to carry it, come strong when we carry it. We used to carry it up and down when we carry it. Yeah, when we carry it, when Wallafield had it, Komoto had it, Malaba had it, Lakita had it, Maloney had it, Point 40 had it, Diego Martin had it, Martin had it.
We're ready. We're ready. Yeah, we're ready. 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 We're ready. We're ready. Yeah, we're ready. 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 Look how the sun now raising up, and the crowd now waking up. The atmosphere have vibes, and nothing can break it up. The girl them a wine non-stop. We have the drinks them in a my cup. We gonna party all night, all night. 24 parties we hit in a row. Tonight at the very last show. Before we are out on the road, the girl them a release the load. So let me see your hands up. So everybody know, put your hands up. So if you're ready for the road, let your friend them know. We're ready. Yeah, we're ready. 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 Yeah, we're ready. We're ready. We're ready. We're ready. The girl them a wait all week. Figure up on the road like freak. The music full of applause with thousands of chipping feet. Everywhere you look is just food, and everybody in a real nice mood. We gonna party all night, all night. Everyone with painted body, clean credit and tainted money. Nobody want to dance by themselves. Everybody wanna dance on somebody. Well, let me see your hands up, so everybody know put your hands up, so if you're ready for the road, let your friend them know. We're ready for the road. We're ready for the road. So we're ready. We're ready. Yeah, we're ready. We're ready. Yeah, we're ready. 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 Yeah, we're ready. We're ready. We're ready. We're ready. Look how the sun now raising up, and the crowd now waking up. The atmosphere have vibes, and nothing can break it up. 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 We're ready, we're ready, yeah, we're ready, we're ready, yeah, we're ready, 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 yeah, we're ready, we're ready, we're ready, we're ready.
Knock a ting, knock a ting, everybody knock a ting, knock a ting, knock a ting, everybody knock a ting, knock a ting, knock a ting, everybody knock a ting, knock a ting, everybody better clear the way when the general come, when the general come, when the general come, whoa. Tell everybody we want it, hot like a job on a Tuesday morning. Clear the way when the general come, when the general come, when the general come, boys. Tell everybody we want him, bad we bad, hey, bad we bad, side step. Anytime we step out it, black outfits stinging like Jeopardy. When we wake, nothing can be powder. They coming back from we head to we crep powder. Do you believe that? Long before Nissan bring Tia, we's the original wet man howdy. Entourage just pull up with 10 howdies. We can't tell how we arm and 10 howdies. Have a squad that's wicked and well bossy. 5 of them in the squad was deported. Whining and yell that hotter than Chipotle. With some slim tea cut out and well bruised. We take a picture, boom, post it up on Instagram. A girl come repost me, somebody repost you. Say that girl is a monster when anything bad, yeah, never snow we. So knock a ting, knock a ting, knock a ting, everybody knock a ting, knock a ting, knock a ting, everybody knock a ting, knock a ting, knock a ting, everybody knock a ting, knock a ting, everybody. Anyway, when the general come, when the general come, when the come boys. Tell them we bow down. No, sir, infidel. Knock a thing, knock a thing, everybody knock a thing, knock a thing, knock a thing, everybody knock a thing, knock a thing, everybody knock a thing, knock a thing, everybody better clear the way when the general come, when the general come, when the general come, go. Tell them we bow down, we party, but like a jack, clear the way when the general come, when the general come, when the general come, go. Tell them. Tell them how we bad, we bad. Hey. Tell them how we bad, we bad. Hey. Tell them how we bad, we bad. Everybody knock a thing, everybody knock a thing, thing. Bad like a jab on a jewelry. Morning thing. Everybody knock a thing, go knock a thing. Whoa.
Front as we fill up the front. Again, we are asking everyone if you are in the back, there's a lot of empty spaces to the front. Can you please just come to the front and fill up some of the spaces? From the love of liberty in the fires of hope and prayer, with boundless faith in our destiny, we solemnly side we stand. Islands of the blue Caribbean Sea is our native land. We pledge our lives to thee. Near every creed and race find an equal place, and may God bless our nation. Near every creed and race find an equal place, and may God bless our nation. I would like you all to please remain kindly standing as we invite Miss Esther Sylvester, Counselor for St. Anne's River Central, for the prayer.
Please close your eyes as we give reference to God. Father, Lord, as we come before you today, no power without you. All strength and power comes with you. Father God, how can all that we are and all that we will ever be is wrapped up in a relationship with you? It is from you alone that we draw strength to face each and every day, and from your reservoir of mercy and compassion that we drink daily. May we witness, be witness to today's authenticity. O God, remove all doubts, selfishness, and arrogance, and impatience, so that the fruits of our relationship with you may cause others to want to draw nearer to you. I say this prayer in your holy and unmatchless name, Ashe.
Thank you, Council of the Honorable Marvin Gonzalez, Chairman of the People's National Movement and Member of Parliament for Aruca Dopino, all party officers, including deputy political leaders, His Worship, the Mayor of the City of Port of Spain, Alderman Chinua Alain, members of Parliament, senators, heads of local government corporations, members of the media, and those viewing live. Welcome to the National Consultation on Stand Your Ground legislation hosted by the People's National Movement. My name is Viash Nandlal, and I will be your moderator for this evening's National Consultation. And those of you who are listening and viewing virtually, of educating, informing, and listening is designed to be interactive and allow for a discussion very serious matter of national importance. In our format, we intend to have opening remarks by the political leader of the People's National Movement, followed by a brief presentation on Stand Your Ground legislation. Our panel of experts will then assemble and engage in a discussion on the matter. And then we get to hear from you, the members of the public, the members of the audience here today. You will have an opportunity to pose questions and engage in a fruitful dialogue and discussion, which we hope will be beneficial to you. So, ladies and gentlemen, without further delay, let us commence our program. I turn now to opening remarks, and it is my distinct honor to introduce, to bring opening remarks, the political leader of the People's National Movement and the leader of the opposition of Trinidad and Tobago. With a distinguished career in public service and in law, she has served our nation with integrity, resilience, and a deep commitment to the people of Trinidad and Tobago. From her early years as an attorney at law to her tenure as a member of parliament, cabinet minister, ambassador, and now leader of the opposition and political leader of the PNM, she has been a trailblazer, breaking barriers and inspiring generations of women and men alike. Ladies and gentlemen, please welcome to the podium to bring opening remarks the leader of the opposition and political leader of the People's National Movement, the Honorable Penelope.
I want to acknowledge His Worship the Mayor of Port of Spain, Councillor Chinua Alain. Let me also acknowledge all other councillors and aldermen. Let me acknowledge the deputy political leaders of the People's National Movement, members of parliament, senators, but to say that we are in the constituency of Port of Spain South. And of course, I have to especially acknowledge my colleague, the Honourable Scotland. Mr. Scotland, where are you? I'm sure, right. Keith Scotland. Thank you very much. So I would just like the opportunity to thank you for the time to attend this consultation. We would be doing national consultations. We would be going next to Central. We'd also be going to San Fernando Tobago as well in the east. Before I get into my comments, I think it is important, and I'm sure you will join with me in congratulating Keisha. I know that, the pride that, and it's probably important that we start successes. But I like that the leader of the opposition is a constitutional creature, of course, pursuant to Section 33 of the Constitution. And as a reasonable and sober opposition, we have taken the position that the legislative agenda of the government is to, of course, be thoroughly analyzed and assessed. Whilst our position is not to object for the sake of objecting, I think you would have heard me very clearly that when I was officially elected as the leader of the opposition, I made it abundantly clear of our willingness to work with the issue of crime is an extremely complex one. We recognize that there are issues taking place as well. Quite recently, what happened in Arima North, as well as another school as it relates in, I think it was in Central. So we know that crime is in our homes. We understand that the public in particular has been extremely concerned as it relates to the number of murders. We have also had the increase in accidents. But at the same time, we want to ensure that when legislation comes before the parliament, we want to ensure that it is good law. So we recognize our responsibility, and we are very grateful to those of you who are here today. To also like to say that continuously provided opportunities for education, sport, recreation for the vulnerable, not limited to financial relief, but including social interventions such as community policing, counseling in schools, community mediation, family planning, early childhood care, and more. And we have always worked towards reducing the root of causes of criminality. It is accepted globally that no society can shoot its way out of crime. Deep result must be treated at the multiplicity of sources. And I don't think anybody disagrees that when you're dealing with crime, it requires a multiplicity of interventions. And with that said, the PNM has not taken the position that we are saying that we are against stand the ground legislation. In other words, we are going to listen. We think it is important that we hear from you. We hear your questions. We hear your suggestions. And it's not just a blanket approach to say, we are not going to listen to what the government is saying. Our position is, let's hear from the public. Let us, as well as we prepare to debate the bill, that our position is going to be influenced by our consultations and your suggestions and recommendations. As a matter of fact, we recognize that in a large measure, stand your ground legislation, as it relates to the confines of your home, is little more than a codification of the existing common law position on self-defense, including the requirements of proportionality and reasonableness in the main. One of the important things is that we have before us some very distinguished lawyers, and you would have the opportunity to, of course, raise your questions and capitalize on the fact they are going to be here with you. So at the end of the day, we are saying to the population that we must be careful about using inflammatory language. You would have recalled that at least one of the ministers made reference to the fact that even if somebody is turned away, you can shoot that person in the back, and that is okay. I look forward to of the various with several other of my colleagues who are here, who are lawyers. We have the Honorable Stuart Young, Senior Counsel. We also have the Honorable Keith Scotland, Senior Counsel. We have Mr. Sanjeev Buru. We have Mr. Farai Masaisai. We have Mr. Larry Lala, Senior Counsel. So we have both in terms of the members of parliament, together with those who are here, that will give the appropriate representation. One of the things that I would say that I am concerned with is to ensure that the public is aware that when you are a perpetrator, the impression that is created that under this stand your ground legislation and something happens at your home, that after the incident, people could comfortably just walk free. I thank you very much.
And inform. And in keeping with that objective, we will have a presentation planned for you. And I would like to invite to the podium someone who's going to present key to seed the conversation and the discussion that we would be having. So it is my pleasure to introduce a very distinguished legal mind and a very respected voice at the bar. With decades of experience in constitutional and public law, he has consistently championed the rule of law and justice in our society. His keen insights and legal expertise will ground our discussion in the constitutional and legislative framework that governs this important national issue. More so, it will give us something to think about and hopefully fuel questions and comments from among you, the members of the audience. So, ladies and gentlemen, please welcome to the podium to give a presentation on Stand Your Ground legislation, Mr. Larry Lala, Senior Counsel.
Good evening, ladies and gentlemen. Because I have very limited time, please allow me very respectfully to adopt the protocols that have been established by our moderator and our honorable political leader. And I will just jump directly into the presentation. The many lawyers who are among us would explain to you that generally there are two types of law that we have. We have statutory law that is passed in the parliament, and we have common law, which is the law we inherited from the UK and has developed over time and been applied over time in our courts, separate and apart from what is passed in the parliament. And I tell you that because there is a very strong argument that the stand your ground legislation is not necessary because of what one finds existing at present in the common law and what is known as the castle doctrine. So what I will do is explain for you basically what the castle doctrine is, and I will address two important factors that operate in the castle doctrine, that is the degree of force that one could use in repelling an attack, as well as this idea of the duty of retreat. When I finish that, then I will go to take you through some of the important provisions in the bill, the changes to the common law that the bill proposes to make, as well as what I see as some of the shortcomings of, in the bill. I'm hoping that I could do that in the 10 minutes that I have left. All right, so let us start. And certainly when we have the panel discussion, any questions that you may have arising out of what is raised here, you could ask, and we will be very happy to answer. So the castle doctrine is a legal principle that allows individuals to use reasonable force, including deadly force, to defend themselves against an intruder in their home without a duty of retreat, right? So that is the castle doctrine under common law. And as I told you, we inherited this thing from England. And as far back as the year 1604, this doctrine could be identified as having been established in the common law. And in 1604, in one case, a judge explaining what the castle doctrine is stated, a man's house is his castle, right? The castle doctrine. The house of everyone is to him his castle and fortress, as well as the place for his defense against injury and violence, as it is for his repose, his rest. And if thieves come to a man's house to rob or murder, and the owner or his servants kill any of the thieves in defense of himself and his house, it is no felony, it is no crime, and he shall lose nothing. Further, in the year 1765, I'm just doing this to show you how far back this doctrine that they are saying they are now bringing into law, how far back it goes and has long been established. So in 1765, it was also said, and the law of England has so great a regard for a man's house that it styles it his castle, it calls it his castle, and will never suffer it to be violated with impunity. If a person attempts a burglary or robbery, it is lawful to oppose force with force. And if the house is forcibly entered in the night and the owner kills the intruder, he is not guilty of any crime. The law rather applauds his spirit than punishes his rashness. All right, so that is the common law. That is what the common law affords you. And when you are operating under the castle doctrine, the issue will arise, all right, how much force can you use to repel an attack on you or your family in your home? The degree of force is this: the person standing his ground in his home in defense of himself, his family, his guests, or his property was allowed to use such force as reasonable and proportionate in the circumstances as he believed them to be. Right? I think that is simply enough for us to understand. In other words, the degree of force used had to be proportionate to the attack that you believe honestly to be taking place. And then there's the issue of the duty of retreat. Well, before you use this force, do you have a duty to retreat? At common law, there is no duty to retreat before using force, as long as the force used was reasonably justified in the circumstances as you believe them to be. Whether you could safely have retreated without using force is one of the factors the court would take into account in deciding whether your use of force was reasonable in the circumstances as you believe them to exist. All right, so that is the explanation of what presently exists in the common law to allow each and every one of us as homeowners to stand our ground in our home and defend our home, ourselves, our family, our guests from an attack on those premises or in those premises. And also at common law, the attacker could be charged and convicted of various offenses, as we all know. For example, robbery, burglary, murder, rape, a multitude of common law offenses and even statutory offenses that we now have that one could be charged for, separate and apart from stand your ground legislation. So, having explained what is in the common law, let me go briefly to the Home Invasion, Self-Defense and Defense of Property Bill 2025. All right, that is the title of the bill that is going to be brought to the Parliament. And let me run through some important clauses of that bill. Now, the legislation is easily available on the internet. Anyone who would like to have a read of it, go on the Parliament website, you will find it. You could take a read of it. It's not a very long a long bill. So you could read it and digest it, and you may have more questions after you do so. So, who does the bill protect? We see that we get the answer to that in section 5 of the bill, which reads, subject to the provisions of this act, an occupant who is in lawful possession of a dwelling house in which that person has a right to be at the material time has A, no duty to retreat from a home invader at the dwelling house, and B, the right to stand his ground and use or threaten to use defensive force to protect himself, another person, or his property from a home invader. Right? So those are the persons intended to be protected by this bill. Who does the bill make an offender? The bill makes an offender persons who are committing home invasions. And we see that in section 6 of the bill, which reads, subject to subsection 3, a person commits a home invasion if, and there's a long list A to K, but I'll just briefly take you through maybe 4 of those items that explain who is a home invader. So a person commits a home invasion if he A, unlawfully enters an occupied dwelling house when he knows or has reason to know that one or more persons is present in the dwelling house. B, unlawfully enters the dwelling house and remains therein until one or more persons is present in the dwelling house. So he's sitting and waiting for you to come in and to do whatever he wants to do. D is invited into an occupied dwelling house and fails to leave immediately upon being asked by the occupant to do so. E enters an occupied dwelling house and then forms the intention to commit a serious criminal offense. F, while armed with a weapon, intimidates or uses force or threatens the imminent use of force on any person within. All right, but there are a number of other circumstances in which one could be categorized as a home invader. I wouldn't bother you with that right now. So the next question is, under the proposed legislation, how can one respond when attacked? And we see the answer to that in section 7 of the bill, which reads, an occupant has no duty to retreat and has the right to stand his ground against a home invader and use or threaten to use force against the home invader where the occupant believes on reasonable grounds that force was being used against him or another person, or that a threat of force was made against him or another person, or that his life or the life of another person was in immediate threat of danger, where he believes that his actions were necessary and reasonable in order to defend and protect himself. It sounded very much like the common law that I explained to you, right? C, where he establishes that the defensive force used was proportionate to the threat that he honestly believed to exist. All of that is what I told you presently exists in the common law. Now, when you take action, what are the factors the court would use in determining whether the force that you use was proper? That is found in section 7.2 of the bill, which reads, and there's a long list of factors that a court will consider to determine whether you acted using reasonable force. I will not go through that long list. I'll just go through a couple of the items, just so you can get an idea of what the section contains. When determining whether the defensive force used was reasonable in the circumstances, the court shall take into account A, the nature of the force or threat, B, the extent to which the use of force was imminent, and whether there were other means available to respond to the potential use of force, C, the occupant's role in the incident, D, whether any party to the incident used or threatened to use a weapon, firearm, or an explosive device, E, the size, age, gender, and physical capabilities of the parties to the incident, I, the nature and proportionality of the occupant's response, K, very important, whether there was a possibility that the occupant could have safely retreated, notwithstanding the fact that there was no duty to retreat. So those are some of the factors that the court will consider in deciding whether the force that you use was reasonable. Very importantly, when the defense does not apply. So under what circumstances is this bill saying you cannot rely on the stand your ground defense? That is found in section 10 of the legislation, which basically says that the defense does not apply among other circumstances when the degree of force used by the occupant is grossly disproportionate in the circumstances. Now, that is one of the key differences between the proposed legislation and the common law, and I'll explain that to you shortly. So, before I go to that, what other change, major change, is the bill making to the common law? One of the major changes that the bill is making to the common law is that it is creating a new offense, the offense of home invasion, right? And that is found in section 6(1) to 3 of the bill, where I went through with you a while ago who a home invader is, right? So I'm not going to do that again. But what section 2 and 3 basically says that a person who commits the offense of home invasion is liable on conviction to a fine of $500,000 and to imprisonment for 20 years. And then who commits a home invasion as part of a gang or as a participant in organized criminal activity or in the presence of a child, a senior citizen, a differently able person or otherwise a vulnerable person is liable on conviction and on indictment to a fine of $750,000 and to imprisonment for 25 years. So it's created, apart from the offenses from which one could normally be charged if you go into someone's house and commit an offense. Robbery, wounding, murder, rape, etc. This is creating a new offense, a specific home invasion offense for which there are new penalties. Now, the degree of force, that is a change that is being made to what presently exists in the common law. You would recall that I told you that at common law, you are allowed in repelling an attack on yourself or your family where someone is using force. You're allowed to use such force as is reasonable and proportionate in the circumstances. Under the bill, that is being tweaked a bit, and the person repelling the attack is being allowed to use a greater degree of force. So the degree of force that you're allowed to use does not have to be proportionate as long as it is not grossly disproportionate. Right? The lawyers will understand the implications of that. But if you think about it, it is self-explanatory. You don't have to be proportionate or reasonable as long as you are not grossly disproportionate. Right? So that is one of the changes being made. And we'll have to ask the question, all right, well, is it necessary to make that change? Are we afforded enough protection in the law as it is now? And with all the protections that the law presently affords, well, all right, why are we still having home invasions? Is the problem the law which exists for home occupiers to protect themselves? Is that the problem? Or is the problem a societal problem or a law enforcement problem? All these are things that we will have to grapple with. And just before my time is up, as the Honorable Leader of the Opposition explained, I'm not certain that in the consultations that have taken place so far and the responses I've seen from persons in the audience, that people understand that this bill does not give you the right to kill somebody in your house. The police come and say, pat you, slap you on the wrist and say, well done, man, good, we go on. They're going to arrest you, probably charge you. You will have to find a bailer, if you could get bail for whatever they charge you for. If it's murder, you probably will have to stay in jail for a long time until you could stand up before the judge and say, Judge, I stood my ground. I'm innocent. I'm not too certain that people really understand from everything that has taken place so far that that is the real implication of what they're being told this big change in the law is going to be. All right, so that is something we will have to discuss as well. And one of the things that has not been inserted in the law that you would find in many other jurisdictions where the law has been implemented is something called an immunity hearing, where if you as a homeowner defend yourself, your family, and your home, and someone dies, the police come, they arrest you, they charge you. You have a right at an early stage to insist on the matter going before a judge. And once you could show on a prima facie basis that you acted, you stood your ground, and used reasonable force, the onus will then be at that very early stage on the police to show that you actually used disproportionate force. In other words, they have not included in the bill that immunity provision, which could prevent persons from having to wait in custody for a long time for a trial if they are charged having stood their ground. All right? That is as much as I want to say. I believe I went about 2 minutes over my time. Thank you very much for a very kind attention.
Special thank you to Larry Lala, SC, for that very insightful and informative presentation. Ladies and gentlemen, we now switch to the panel discussion section of tonight's consultation. And I would invite our 4 panelists to take their seat at the head table and engage initially in a conversation on the bill, on the presentation, on Stand Your Ground as presented by Larry Lala SC. And also, then we will move into a section where you, the audience, will be able to ask questions and make comments. So firstly, the first member of the panel, I would have already introduced. I would invite Mr. Lala to take his seat. Thank you. Yeah, you can take number 1. Next, we welcome an attorney at law and deputy political leader of the People's National Movement, a dedicated servant of the people and advocate for progressive policies. He brings both legal expertise and a deep understanding of governance to the table. His perspective on how this legislation intersects with national priorities and the lived realities of people will be invaluable in this conversation. Ladies and gentlemen, let us welcome Mr. Sanjeev Budu. And of course, we cannot just have a panel full of attorneys. We need another perspective. We are also joined by a well-respected psychologist whose work has focused on social behavior, community safety, and mental health implications of crime and justice. His expertise will help us understand the human and social dimensions of the Stand Your Ground debate, particularly how such laws impact family, communities, and the psychology of safety. Ladies and gentlemen, please welcome Mr. Sule Joseph. And finally, it's an honor to welcome another attorney at law with extensive experience and extensive legal practice. His career has spanned a wide range within the justice system, and he has consistently brought sharp analysis and advocacy to the legal profession. His contribution tonight will provide an informed and practical perspective on the legal implications of Stand Your Ground legislation. Ladies and gentlemen, please welcome our 4th panelist, Mr. Farai Hove Masaisai. So as I said, we're going to engage in a short discussion where the members of the panel will present their initial perspectives and points of views on Stand Your Ground legislation. And I have some prepared questions which I would use to generate this discussion. So I will begin with Sanjeev. First of all, Stand Your Ground law, where does it fit in terms of public policy as a tool to tackle crime and criminality?
Good evening. Good evening, VH moderator, political leader, Your Worship, the mayor, fellow panelists. Good evening, everyone. Thank you all for coming out. And I will take the opportunity on behalf of the panelists, as I'm the first contributor, to express my gratitude and excitement to participate in this with you this evening. I mean, just very briefly, context. I think context is important, right? So contextually, I see this bill in the main being part of a larger framework of legislation that can have the potential to peg back crime, to address criminality in society. It certainly is not. It is certainly not a silver bullet. I think that there is a significant procedural defect in it, and Senior Counsel Lala touched on it at the in the absence of the immunity hearing. So I see that is a procedural defect. I mean, the legislation stops short of addressing what is to happen to the homeowner who stands your ground, so to speak, on relying on this legislation, who then finds himself in jail for a very long time, having to prove innocence in relying on this piece of legislation. Other than that, my main issue, and again, it goes to context, is the way that the legislation has been presented to the public. This legislation has been presented amongst language such as load up the matic and empty the clip and that sort of thing. And from my observation of the bill, it does nothing to allow anybody to do that. And I mean, the first real reality, if it is you want to have the discussion about loading up a matic, you have to first have the matic. And what is this legislation, what does this bill do to address the absence of the matics in the hands of law-abiding citizens? So if it is that you want to introduce legislation that is pursuant to your legislative agenda of addressing crime, and that is all well and good, there's been a change in government, and with that you expect that there is a different legislative agenda as compared to what has held for the last 10 years. Nothing is wrong with that. I mean, that is part of the democratic system. But if it is, you're proposing this as part of a larger suite, because that's the way it's been introduced, the issue of getting legal firearms into those who qualify and are suitable owners and responsible owners of firearms, so that to create the narrative that this legislation is going to permit you to load up a matic and knock it on them is simply misleading and inflammatory, and I think it is reckless and dangerous, and it's not a true representation of the legislation. So those are my initial comments. And to close, it is not that I do not see this legislation as being useful. To be clear, I do see it as being useful, but it has to be introduced contextually right, and it has to be part of a larger piece of framework legislation.
Okay, thank you, Sanjeev. I want to bring the psychologist, Sule, into the conversation here. And Sule, my question is this. This country has seen, it's no secret, an increase in crime over the greater part of the last 2 decades. My question to you is, what impact has that had on the psyche of citizens? And how does that create the conditions to make stand your ground law a little more palatable at this point in time?
All previous protocols observed, for this interest of time. Good evening to everyone. Good evening, everyone. All right, thank you. Talking to myself would mean I have some kind of mental illness, right? All right, okay. A couple of things I want to address. First, I want to say that I am by no means a legal mind, so I am addressing it through my expertise, right, as a psychologist. And as I understand the legislation as it was explained to me as I read it, right, and what the impact can possibly be. Now, if we take as fact that there is an increase in violent crime and so on within the nation, what a fallout definitely will be is that you will have what we call hypervigilance among your population. That's just a big fancy word, people, to say that everybody will be looking over their shoulders. You'll be jumpy. Right? And this is something that you would have been living. You would have lived a jumpy feeling. Walking down a dark street, hearing a noise in the night, even in your own home, you are going to be jumpy. So crime and the increase in crime is going to increase that hypervigilance, that sense of nervousness, right? You're going to be functioning, or a lot of us may be functioning in a fight or flight mode at a consistent basis. That's going to increase stress, anxiety. It's going to increase the likelihood of easily triggered behaviors. What I mean by that is, if you're in a jumpy space, if you're in fight or flight, and somebody touches you on your shoulder, you're likely to spin around and hit them a lash, right? Because you're jumpy. So those are things that we have to consider when we having a conversation about loading up the matic and emptying the clip on them and so on, and shooting anybody who comes into your yard, and finding out afterwards if they are police officers or not, right? That's something that we have to take into the conversation.
Okay, thank you, Sule. I would like to bring in Farah into the conversation as well too, and a question that I think any of the attorneys, including yourself, Mr. Lala, could address. And really, this relates to the Constitution, and we have a bill which has been presented, which is before us. And the question is, how does this conflict, if at all, with the Constitution in terms of rights and freedoms?
Well, I'll piggyback off of Senior Counsel's introduction. This bill seems to try to codify the common law. So for me, it's nothing wrong with codifying the common law. So you're putting the common law into writing. And certainly you're going to be affecting fundamental rights. Yes. We know we have a constitutional right to life, a constitutional right to liberty, security of the person, and so forth. The bill seems to bring in to the statute a right of the occupant who's in lawful possession of a dwelling house to exercise that force. For me, as a civil and constitutional attorney, that term lawful possession is a term that really needs defining in the act. Because you could be in unlawful possession of a property, this possession rights in Trinidad, and it really clear. I am living on a property for 15 years unlawfully, knowing that one more year I can probably apply for a vesting order, or I can bring the lands under the Real Property Ordinance or the Real Property Act. Is it that I'm in unlawful possession of that dwelling house? So you're creating scenarios where good constitutional lawyers will pour holes in. Yeah. So another thing with this act, which I'm looking at, is that when we look at the comparator that was used by the Law Commission to come up with the bill, there's no comparator like Trinidad and Tobago. There's none. Florida is not like Trinidad and Tobago. It's not culturally the same. It's not racially the same. The population side, it's way different. The other Commonwealth jurisdictions where they use are not like Trinidad and Tobago. So what I would have liked to see was a sunset clause in this act. Certainly to have some statistics to go with whether it's making sense or not. You know, we can't just take what is going on in Ireland and say it will apply here in Trinidad. It just doesn't work like that. And certainly we don't have a culture. We don't have a culture of persons wearing arms in Trinidad. Whereas in Florida, there is that culture, you know. So from a constitutional perspective, I think it's something that it's a major piece of legislation coming in. And certainly we have to educate our people. As my friend on the panel quite rightly said, it's not about shooting and asking questions after. There's literally no clause in the act that covers what is the process after I shoot or I dispense with this intruder. You will go back to the common law. Yeah?
Thank you. Thank you, Farai. And I would ask Mr. Larry, would you care to weigh in on that question as well, too?
What is troubling me is why is there a need for this legislation, and what is the reason why it is being pushed through? If you are codifying the common law, then certainly it would have made sense to use the resources available to the state to educate persons on the rights they already have under the common law, right? If you believe that persons are uncertain as to the circumstances in which they could defend themselves and their families if they are attacked in their homes, then certainly it would have made sense to educate them on the rights they already have in the common law, right? Why attempt to bring this legislation to give the impression that you are doing something so novel and new when you really are not? You know, you're making a little tweak to the law here and there, but essentially you are simply reinforcing the rights that people already have. So one has to ask the question whether the approach being used to bring this legislation is really an honest and forthright one, right? And why it is being done in this manner.
Okay, thank you, Larry. And then I will ask a final open question, which members of the panel, and after this we would go to the questions and the comment segment. How does the provisions in this bill and what we see before us different from what was promised on political platforms or even spoken about? I would ask Sanjeev, can you start?
Yeah, as I said earlier, that is one of my main difficulties with the legislation. It's not the legislation as drafted, but for the procedural issue, of course, it is the communication of the meaning of the legislation or the lack thereof, I should say, or the miscommunication. This legislation does not allow anybody to empty any clip on anybody else under no circumstances. It doesn't give that protection. It gives you very, very close to the same common law protections as if someone were to enter your home and you are able to stave them off. You are able to defend your family, and you do so reasonably, and you do so with some degree of proportionality. That's what it does. It simply codifies the position. So again, I don't think any sensible person is going to say this legislation ought to be rejected. It ought to be presented to the public for what it is. It is a very close codification of what exists already. But I am happy that you asked that question, because it leads to another issue, right? And it is, what is the legislative responsibility of the government? It is to introduce legislation that ostensibly fixes some problem. And we have to ask ourselves as a population, well, what problem are we solving with this piece of legislation here? What problem exists in society? How many, in terms of numbers, how many times have we seen recently in the last 5 years, how many times have we seen homeowners using a licensed firearm to shoot an intruder and being arrested and charged for some crime and not being able to successfully defend it in court? That's the question. And that has to be the driving force of introducing any legislative reform or new legislation into the parliament. There must be an issue that you've identified that you either want to correct or adjust, or you foresee the possibility of an issue which you want to preemptively address. So that's generally speaking why you introduce legislation.
Thank you. Farai, I know you wanted to respond.
Yes. So I believe the question is, how does this bill compare to the rhetoric on the platforms during election? So the bill is couched as an act to establish an offensive communication. Senior counsel has guided us this afternoon. There is already an offense in common law. The castle doctrine, yeah, 1604. A man's home is his castle. Yeah? So it's not establishing anything new. It also puts it in the context to provide that person that there is no duty to retreat. And that in itself is a deceit to the population. Although it says it has no duty to retreat, what does the court has to take into consideration? One of the things the court has to take into consideration is whether or not the party could have retreated. Yes? So if the court, meaning a judge, is factoring that in exercising his discretion whether to hold you that you have not complied with the act, then certainly you can't tell the population that there's no duty to retreat. That in itself is wrong in law. Yes, you have to consider your options. You have to consider your options wisely, because the court will consider it. Could you have retreated in these circumstances? One of the things they also consider is whether the person has a disorder. And we know that some elderly persons may have dementia. So if they go into a property that is not their own through having that mental disorder, is it that we just get rid of them? And, you know, because the act speaks to things like immediate. So once I tell you to get off my property immediately and you don't, that term immediately is very subjective, you know. So I'm saying that it does not reflect their political rhetoric. It is how it is couched and how it is framed it is framed sensibly in terms of the common law and in terms of codifying the common law. What is not there is what is to be done when I exercise my right under the statute. And certainly that immunization hearing, immunity hearing is something that should be considered. Yeah?
Thank you. And Sule, I know you are going to respond to this, but I just want to add something to it as well, too, seeing your background. If persons are of the belief that they could act in a particular way, how does that impact now, especially seeing that the reality may be differently? And that's part one. And part two, do you see this potentially making Trinidad and Tobago into a more violent society?
The first question, the first part of the question, a little bit easier than the second part, right? You're asking me for some psychic abilities. However, so let me address the first part. There's something called cognitive dissonance, right? And I have some significant concerns with the fallout, the psychological fallout of the population when, at least based on what the learned persons around me are saying, the SC and the rest of the learned persons, if their interpretation and what they're explaining to us, and based on what I've attempted to read, is accurate, then there's a massive divide and gap between what is being said to us or what has been sold as a package versus what the legislation actually says that we can do. And when the reality hits you, right, it's like thinking you're expecting to get your entire salary at the end of the month and you're planning and you have your bills and you have all of this that is ready. And then the end of the month comes and you get less than half of your salary, which I believe happened to, okay, right. And then you get less than half of your salary. You already have all your bills and so on. There's this dissonance that occurs. Your brain takes a while to process and say, but wait, this is not what is supposed to happen. How do I treat with this? You have already primed yourself to load up your matic. You've primed yourself to feel as though that you have a legitimate expectation, I believe is what is said in law. Right? You have a legitimate expectation that firearms are going to be more readily accessible, that you can, you will have a firearm available to you. You could shoot anybody who you feel threatens you and so on once you're on your property. I heard people already talking about, well, my property extends to my vehicle, right? And I'm just going to ask, anybody here has road rage? Anybody experienced a bad drive in Trinidad and got angry? Could we imagine what it would be like to have a firearm in that situation? Everybody randomly has a firearm and we just experience road rage. Instead of jumping out your car and slapping the person, what do we do then? Do we shoot the person? Right? So there's going to be some cognitive dissonance. And I'm worried. I'm not saying that it is definitely going to happen, but I'm worried that despite what the legislation says, people are already solidified in their minds. They have a thought process of what is going to happen once they get their firearms. Once that happens, that they have correct the legitimate expectation, which has solidified a cognitive bias. Once that happens, all right, I have concerns that people are going to develop what we call Superman syndrome, which is anybody talk to me rough, touch a button, right? I am legitimately going to open up my matic. And so I have concerns about that in a population where we already, we talk about us being, yes, we're a loving people and so on, but we also we are quick to emotions. We quick to anger in the moment, we quick to react in the moment, and then we calm down after. We can't calm down after you hit somebody 6 shots or you empty the matic on the person. After you calm down, the person is already deceased or passed or the action has occurred. So I do have concerns about that. That's the first part of the question, right? The second part is if there would be
if there's a potential, for us to become a more violent society.
Based on what has been promised, right? Not necessarily what has been written, but based on what has been promised, what you are saying, what I get is that you're saying to me, once I feel threatened and I'm in my home or in my property and so on or whatever, there is no real consequence to me opening up my matic, right? There's no consequence to me having extreme action. That is what's being promised to us. Not what is in the legislation, but that's what's being promised. So as a layman, that's what I'm hearing. That's what's in my mind. And what happens when you remove consequence from people with who may potentially have behavioral issues is that now there's nothing preventing you from lashing out. Yeah, if I know, if I open up my firearm once you on my property, whether you come to Tifa Zabaka or deliver papers, right? If I find out my wife is having an affair with the pool boy and I decide I'm going to shoot the man right on my property, I will feel more empowered to do so because I may believe that this legislation provides me or covers me, provides me with the ability to be able to open up my matic, right? I believe you even told shoot first and find out if it's police after, right? If I remember correctly. So, I'm trying. And I believe those statements, we have to be, I'm concerned about that because it is inciting a potential culture and you're stoking a potential fire in the populace. That is something to be very concerned about.
Thank you very much, Sule. And I think this is a good point to transition into the discussion with you. And I hope that this discussion, the presentation, would have found fertile ground with you, the members of the audience. And you are now ready with your perspectives, with your questions, with your comments on this. But before we move forward, I would just like to go through some ground rules. So firstly, as you come to ask your questions, you would see a mic in the middle there. I would ask you to line up very orderly, one behind the other, and limit yourself to one question or comments if you can, please. And in doing so, in asking, if you could take less than 1 minute. I know sometimes we tend to give long preambles and so on. Sometimes that may not be necessary in this case, and we ask you to be very direct. We ask you as well, I know persons may tend to come and go through the protocols, simply stating all protocols observed, or I stand on all protocols established would be sufficient. We also are asking that you be very respectful at all times. If the moderator must intervene, I will intervene to bring back the conversation. And again, the consultation is on the issue of stand your ground legislation. We have had a lot of information. We are kindly asking that you keep within topic. So with that being said, ladies and gentlemen, and I know we will have your cooperation as well, we open the floor and we ask you all, and we open the floor for questions, comments, and we ask you all to line up in an orderly manner and ask. Yes, sir. Please, as well, state your name and constituency if you can.
My question, given my understanding of both sides, which finds an opulent specifies the fact that we're looking at the dwelling house and the rights to be in that property. I have a hypothetical for our lawyers, and that is, I'm being threatened, I'm fleeing for my life. I burst into my neighbor's place. I do not have legal rights to be there. I grab a knife because I am threatened. I use the knife. I bring the other person's life to an end. Does this legislation authorize me to do that? Or am I supposed to take what comes my way because I don't want to break the law? Thank you.
Okay, thank you. Larry, let's see.
Well, I would answer it, I'll answer the question this way. In order to rely on the defense, you will have to satisfy a court that you had a right to be at your neighbor's premises at the particular time. Whether you are able to establish that would depend upon a lot of facts and circumstances existing at the particular time, including whether your neighbor like you or not.
Okay, does anyone else have a perspective as well? Farai?
I think there's something in the act where it allows a third party. I start to call it a good Samaritan clause. A third party could defend an occupant. So, as senior counsel quite rightly said, it really depends on your relationship with your neighbor, because your neighbor will be the defined occupant. You would be a third party in your neighbor's property. If that person has a knife and obviously is threatening not just you but also your neighbor, then you could probably fall within that good Samaritan clause. But it depends on your neighbor.
Okay, thanks. Oh, yes,
So
sir.
what happens if my neighbor is not home when I burst into his place for shelter?
We need to get a criminal lawyer.
Well, so if I could put it this way, where my mind goes is again, outside of this legislation, if it is you walking along Frederick Street and you feel threatened and you retreat, which is what you've described a retreat, and your back is now against the wall and you have a knife and you use the knife in self-defense, and that self-defense is proximate, then you have a good defense. You have a good defense in law. You've defended yourself. That you've already retreated in any event. It comes back to the question that I have been asking myself: what is the cure that we are getting here? And you are not ignoring the fact that look, we have established we're proposing to establish a new offense. I mean, the truth is, again, coming to the point of solving problems that we may not have. I am not aware that anybody has broken into another person's home and the police have said, I can't find any law under which to charge you, right? So in as much as we are creating new legislation, and this is a little bit stopping a little bit short in saying, well, we're doing nothing more than codifying the common law. Yes, we've created a new offense, and that's all well and good. And yes, we've codified certain things that the common law may not. But again, my mind is, what is the problem we are curing with this legislation?
Okay, thank you, Sanjeev. Ma'am?
Hello, Shanda O'Neill, pronouns they, them. See, I'm a concerned citizen. I guess this is kind of addressed to the psychologists a little bit. They touched on it with hypervigilance, but I'm representing, I guess I can say, the queer community. So we live in a conservative society. So how, well, technically, it sounds like this can be used in like a gay panic situation where something happens and maybe in, like, I'm just speaking from what I understand, if certain, like if masculinity is threatened, sometimes escalate a little bit, and that could result in a little bit of, well, just violence. Just trying to keep, what I'm trying to say. So how do we codify this whole standard defense in a conservative society where people have gay panic? Thank you.
Sule, would you care to take that question?
If I'm understanding the question correctly, essentially you're asking about potential gay panic or concerns about the LGBT community and how this law could impact that. Yeah. All right. What my concern is, take it back a bit. My concern is, I will tie it back to the concern about the cognitive dissonance. And one of the things I would advise that we look out for is potential vigilante groups for vigilantism. And when those things happen, like vigilante groups tend to target specific communities and groups. Yeah. And so it is possible, I'm not saying that it isn't at all. It is possible that a group of persons, especially as you put it, a conservative society or conservative space, can become a targeted group for vigilante groups. Yeah.
Especially in a space where now we're having a conversation about this not being able to losing jobs,
I'm thinking it's affecting that community as well. How then do we protect the vulnerable from potential vigilantes? That's a conversation that we need to have. That's definitely a conversation we need to have.
Okay, thank you. Sule? Ma'am? Oh.
Good evening, all the staff. BounXup, Jennifer I've done some reading, and there's an aspect of study that has been. It's about the racial disparity, racial bias. And why I'm concerned, because I heard Mr. Guru said that basically the UNC or the government kind of romanticize standing ground laws. You just shoot people. You can get off here, the Minister of Justice, as you all said, shoot in the back. Why I'm so concerned, we had recently a pundit from Arangwells saying that urban youths from the East-West corridor targeting Indians in Arangwells. Now, to some people, when you hear urban youths, East-West corridor, you think of African youths. And when you hear some people, think of PNM people. So I'm saying, if we are hypervigilant, as the psychologist said, and an African youth goes into the Arangwells community based on the hyperactivity and what the pundit would have said, because pundit is a respected person in the community, would we be in a position where we could get shot down easily? Our sons, our daughters get shot down based on the fact that that pundit would have said that urban youth from the East-West corridor targeting. So under hypervigilance, under the fact that people are hype up thinking that you can shoot somebody down just like that, are we to be concerned in certain communities about the safety of persons of African descent? That really is my biggest concern.
Thank you. Farai?
Yes, Ms. Frederick. It's a legitimate concern. It's a legitimate concern, and certainly being a responsible party that the People's National Movement is, this education drive is important. You know, when rhetoric is being said on the political platform, it is important that you have a responsible opposition. And I'll take the time to commend our opposition leader for having this discourse. So the people, we suffer for lack of knowledge, yes? And certainly we shouldn't suffer for lack of knowledge. So we have to speak to our members and educate our members. We have a duty. We owe them that duty. Because if I wasn't a seasoned attorney, because younger attorneys could really take what learned senior counsel Ms. Pisasa says as fact. We could roll up the matic and knock it, yeah? And that's, as a young, naive attorney, you might say, well, coming from the Prime Minister, as my psychologist friend says, you could get a legitimate expectation, high office holder. We have a duty to educate, and that is what we are here to do. We are here to educate, and we thank the media for being here, so that there is some level of sanity in this conversation. Yes? So your concern is legitimate, and hopefully by having these conversations with the entirety of Trinidad and Tobago, they will understand what the position is. Yes? Ms. Frederick?
Thank you very much, Mr.
Could I just add quickly that I agree that's an important point raised. One of the concerns I have coming out of that is that it can lead to probable erosion and disintegration of community trust. And if you're talking about erosion of community trust, it can rapidly disintegrate and break down into ethnic distrust. That's So while it may exist in some corners and so on in a very low-key manner, I am fearful if we don't have these things addressed publicly and openly and have the conversation about it, that it can lead to that, to this ethnic distrust. Yeah, and we load up the matic and empty it on them happening in one direction.
Okay, thank you.
I
Barry?
just want to add to the discussion without attempting to get too controversial. And that is that the legislation is being proposed by a government where the leader of that government recently said, when we had the vessel being blown up on the high seas, contrary to all established principles of international law, kill them all violently. Right? And when you look at the comments on social media by our wider society, you see a lot of people finding nothing wrong in that comment. And that is scary. And it ties into what the point the good lady is making. You know, are we communicating to the psyche of our public that it is okay to kill persons without due process, and at the same time attempting to bring this type of legislation into place? And I think it is something that just to pause and think very carefully where we're going to decide if we go there.
Thank you. Sir, I was just individual comment to make. Sir?
Good evening to all. My name is Romain Ignacio. I'm from Arima. In my understanding, when legislation is put forward, it should be for everybody. This piece of legislation, I am concerned that from all the rhetorics with anti-dematic and so on, it seems as though the legislation is to protect people who have firearms. What about those who do not have firearms? I know a member of the panel mentioned that legislation should have been brought forward that everybody have the opportunity to access. I heard the police say everyone could apply, but we know what the law says. The Commissioner of Police has the authority to approve. I suggest that if that law is to be passed, the authority that the Commissioner has should be removed, and he should have the authority to deny from a criterion that would be set for a person everybody could access, and not only who is approved. That is my comment.
Thank you very much. And Sanjeev, may I ask you to comment on that?
Thank you. So, the thing is, sir, I believe that we're coming right back to the core issue of messaging. You see, you said that your takeaway from this legislation is that it benefits those who have firearms. And I suspect, and I'm subject to your correction, sir, you have concluded that because of the messaging that surrounds the proposal of this bill, because of the narrative that was portrayed both on political platforms and in the media, right? But the thing about the legislation is it isn't specifically, in fact, I don't even think it makes very much mention of the word firearm at all. It allows certain defenses to arise, a codification of the common law, so that if you were to arm yourself with a cutlass or not arm yourself at all and defend yourself, the legislation seems to cover that. And that's why I keep saying that my difficulty really isn't with the legislation or with the introduction of the bill. It is the messaging that comes with it or has continuously to come with it. And on the general topic, I would like to point out that, you know, we as a people, any country, you depend on leaders to lead and to lead responsibly. And we trust our leaders to balance the scales, as it were, in the country, in any country. And so there cannot be a denial that crime is a serious situation that concerns each and every one of us, and we need to be concerned, and we need to do everything in our power to arrest that situation. But at the same time, is the way this legislation has been pandered to achieving that result? Is this bringing a true balance? And as I've said before, I cannot as yet find the problem that this bill fixes. But the narrative that comes along with the bill says that we are fixing altogether, almost, the issue of home invasions. And I'm not so convinced.
Thank you, Sanjeev. Ma'am?
Good afternoon, all protocols observed. My name is Alana Morton from Portishead, North St. Francis. About 2.5 years ago, I experienced a home invasion. It was 2:15 in the afternoon, hot sun, Saturday. 5 of us were at home. 2 of us were inside, 1 was upstairs, and 2 other people were outside in the backyard. The terrorists did not quite know how many people were actually home. So while they pinned my father and myself down at gunpoint, 3 came inside, 1 was outside as a driver, so there was 4. 2 went upstairs to search my house and encountered my brother upstairs and beat him. My father and I were at gunpoint and were searched and robbed, and my mother and my other brother were in the backyard and did not know what was happening. And all I could do was pray that nobody came inside unexpectedly. Unfortunately, my other brother came inside, met the gunman, got shot. Now, I say all of that to say that I don't support that law because there was no way that even if I had a firearm, would have been able to defend myself. I couldn't pull my cutlass, couldn't pull my kitchen knife, nothing, because of how we were pinned down. And still someone got shot, right? The police, we can't even get them to do regular patrols in the area and there were other home invasions. A man got kidnapped 2 streets away and we don't get regular patrols. So for me, the law doesn't work unless the police enforce it, and the police not enforcing anything. They're not catching anybody. 2.5 years later, our terrorists still out there, as far as I know. There's no case. So this makes no sense to me. The other thing is, I noticed that the law has a fine. Which when they're paying that fine, and to who? Because those of us that are injured or killed or maimed, because my brother's arm is still not healed 2 years later, right? We have no compensation from anybody, be it the state or the criminal. So that fine makes absolutely no sense to me, right? And with the law, as you all have pointed out, the law is contradictory in how it is being applied. Like they're trying to just pull Florida law here. Now, as brought up by Ms. Jennifer here, with our race issues, I can't support a proliferation of firearms in the society. You all talk about road rage. That happened already. A few years ago, somebody jumped on the car and forced out the traffic light and shot somebody that gave them a bad drive. That has happened, right? So we're not even questioning that if it could, because it has happened. So I can't agree with that either. And studies everywhere show a proliferation of guns is bad. It does not end well. And we've seen it every day in the news, so I don't understand. Other than that, if you are not the homeowner, but you live in the house, how does the law affect you if you defend the household? I'm not the registered household owner. So what would happen if I give them a tree line and slice off the man I would I'd be still waiting for bail. And to Mr. Voodoo, the reason for the law is to satisfy a populist imperative. That's the only thing I could see. It is populism that these people are practicing, and we are creeping to fascism. So that is what that is. And I would ask Sule, we talk about cognitive dissonance, but that point that there's a point where cognitive dissonance becomes purpose. So I don't think it's just dissonance anymore. I think there is a purpose to, even in the light of being corrected, to continuing to promote and push a certain rhetoric and narrative in order to get a certain result. And I am not one to take handle as seeing it. I don't know who else not seeing it, but I am seeing it. So we are in dangerous territory. We are in a slippery slope, and I don't know who's going to save us.
Okay.
Have a good
Thank you. Thank you, ma'am. Panel, we have a couple of questions and a couple of comments. I don't know who would like to begin by responding to any. Larry?
Just in relation to being in the house, but you're not the owner, the act or the bill, sorry, has a very broad definition as to who an occupant is. And once you're there lawfully, even as a family member, the act covers you as an actor standing your ground. Right? That's just what I wanted to say in relation to what the good lady raised.
Okay. Farai?
Certainly, Alana, you give us a lot to think about there, as usual. But Alana, one of the points that I definitely would like to take from your conversation is that issue of compensation for victims. Certainly, if you have a penalty of $500,000, where does that go? You know, there used to be a criminal injuries compensation board. I don't know if they appoint that board yet. Is it still like this? They waited, right? But certainly, that is a serious issue. The monies collected as a result of this should really go to the victims, you know.
So my brother did try to access it because one of the outcomes, as I said, is that he's not healed. And while his doctors are of different minds about what to do to solve the issue with his arm, one of the things would have been to travel abroad to get the surgery. That is 50,000 US. We have a Forex problem. And on top of having a Forex problem, I don't have 50,000 US. My mother doesn't have 50,000 US. I would have to do a crowdfunding something. Or crime. And I don't have the stomach for crime because I don't like jail. But he did attempt to apply to the injury, criminal injury, whatever.
Yeah.
But that's still with no resolution because everything in this place moves slower than a giant African seal.
Yeah.
Okay, thank you.
So that definitely, if really the government is serious about this, that is a clause that should be added, a compensation for victims of home invasion. Yeah.
Okay. Sule?
Yeah. Alan, I want to start by saying I felt traumatized by hearing your story, right? That sounds like a very traumatic experience to have for anybody to have. And as much as I can, I empathize with that situation. I'm really sorry that you and your family had to go through that. I can't say that the legislation says it, but the energy and the wording that has been shared with us openly encourages, which is the thought patterns that I'm having some concerns with, encourages us to believe, or rather me to believe, that the government has kind of thrown their hands up at how to deal with crime and thrown the responsibility for policing your own space back on the resident, you, the person. So now you are now responsible for policing, I guess, your own home. What happens when you're gathering groups and decide to police your own community? And so that is where my concern comes from, the potential for vigilantism, right? With persons now believing that you can't get onto police. They never have a vehicle. They're not patrolling your area. Their concerns and issues and so on and so on and so on and so on, right? that is a legitimate concern and legitimate fear, which could also lead to some concerns that I also have about a false sense of security. Because persons having a firearm don't mean you're secure. As you pointed out in your instance, even if you had a firearm in that situation, you would not have been able to use it. They might have stolen it actually. Right? Correct. So they searched your home and they might have taken your firearm. So there may be this false sense of security that is developed across the minds of the populace. And everybody may feel, you have a firearm, you did some training and so on, and I guess you're a gondolero. So you can protect, you can protect your home and the community. That may not end very well. That's a significant concern to consider.
Thank you, Sule. Sanjeev?
I'll try to be as quick as I can, but it has arisen out of Alana's contribution as well. And I would like to refer to a study here. It's a 2022 study, and I'll try to be as succinct as I can. And really, the 2022 study estimates that expanded legal protection for individuals who use deadly violence in self-defense result in an additional 700 homicides each year, an increase in monthly homicide rates of 11% nationally, but up to 28% in some states. And this is a study that was conducted in the US and published in the Journal of American Medical Association. And it goes on to say, according to the 2022 study, the enactment of stand your ground laws led to an overall increase in homicide and firearm homicide across the US. While impacts vary from state to state, no state saw reductions in homicide following the introduction of stand your ground laws. And southern states, including Alabama, Florida, Georgia, and Louisiana, saw particularly large increases. According to the research team which conducted the 2022 study, the accumulation of evidence suggests that the expansion of self-defense laws in public places may escalate violence and result in unnecessary loss of life. According to this 2022 study, supporters, that is pro-firearm supporters, argue that introducing stand your ground laws will improve public safety by deterring criminals. But the research team's findings indicate the opposite. Now, let me shock you even more. This that I just read from is paragraph 4.8, 4.81, 4.82, and 4.83 of a document published and found on the Office of the Attorney General's website, and it's entitled Protection Against Home Invasion in Trinidad and Tobago, an Examination of Stand Your Ground and Other Self-Defense Laws, the Law Reform Commission of Trinidad and Tobago, July 2025. This is the document here. I pulled this off of the AG's website. It is on the front page of the AG's website. You can go and look at it. The other thing I would say is, well, in terms of removing things, right? Let me just say, I was going to close with this, but I'll start with it. No statistics available on TTPS website for 2025 as at the 17th of September 2025. That means up until the 17th of September 2025, the TTPS website no longer has statistics published. And I think I know why. You see, on robberies, between 2015 and 2024, there was an 18% decrease overall in robberies. And lastly, dwelling house. Between 2015 and 2024, there was a 53% reduction. Those are statistics from TTPS website. Maybe we know why they no longer have statistics being published. Now, what concerns me as it relates particularly to Alana's contribution, though, is while we have had an increasing rate from 2019 to 2024 of detection, the detection rate, it has been increasing. It is increasing, in my respectful view, at a far too small increment, and generally speaking, remains at a far too low of a rate, which in 2024 was 21% in respect of robberies and only 12% in respect of larceny, dwelling house. So those are the concerning facts. But overall, we have seen reductions, 18%, 53%.
Thank you for that insightful information, Sanjeev, as well, too. I see His Worship, the Mayor of Port of Spain. Mayor?
Thank you very much, and please permit me to stand on the protocols that are already established. Correct. I too am concerned that the branding around this policy position by the government is around stand your ground. So I was interested to read the Stand Your Ground bill. But what I ended up having to read was the Home Invasion bill. And those are two very different things. And I think that the difference between those two things would be mixed up in the mind of the population. The question that I have for you is, we have several people in this country who they have a property and they live upstairs, but they have the business downstairs. So does the Home Invasion bill only extend the upstairs of your home, place where you live, or does it also extend to the downstairs where you might have a shop or you might have some kind of business running, a hardware or whatever it is? And if you've closed your business at the end of the day and you're inside the downstairs, but the place closed and somebody breaks in, do you have to then, you have a duty to retreat? And you have to retreat to upstairs before you can stand your ground. That is the question I have. And one of my colleagues, as they saw me get up, they text me a question to ask. If you live on a property where there are several apartment buildings, and you might be paying a fee, and all of you own this condominium or this complex together, in the yard, all that yard, is that where you can stand your ground as well, if you're living in a big compound, a big property with multiple apartments? So those are my questions. Thank you so much.
Thank you. Sanjeev? Thank you very much, Your Worship. So, Your Worship, under section 4 of the bill, there are two definitions, very wide, as Senior just pointed out, right? It speaks to curtilage, and it says, in relation to a dwelling house, it means an area immediately surrounding or adjacent to the dwelling house, which is used in conjunction with the dwelling house, regardless of whether the area is fenced, there is a natural boundary, it is enclosed in a manner that indicates the occupant's intention to define a boundary, so to speak, or keep people off his premises. So, in other words, even an unfenced premises in the situation you presented with the business downstairs, a lot of those businesses don't have fences to the front because it's a car park. Even in that circumstance, the definition of curtilage is covered here, but it says it does not include any other part of that area that is a public place. Now, that's the but for in it, right? So that insofar as the business is open and running and open to the public, you may run into a problem. It may not during working hours then, or business hours. It may not be covered by the definition of curtilage, because it now becomes a public place once you're open, and therefore you have invitees just by the fact of being open, also not express invitees. And then there's a definition of dwelling house, and it goes on to describe a dwelling house as any structure or part of a structure, whether permanent or temporary, whether fixed or capable of being moved, which is designed or adapted for use as a dwelling or residence. Any adjacent land, building, or other structure within the same curtilage as a dwelling house and occupied for the same purpose or an associated place, a boat, ship, or other vehicle in or on which a person resides, which has been designed or adapted for use as a dwelling or residence. So it also goes to, I think, Sule raised a question as to whether this legislation covers vehicles. Well, insofar as you live in the vehicle, it covers you. But if you don't, then it does not. So there are some broad definitions there.
Thank you, Sanjeev. Farai?
Just hire a senior counsel, yeah? No, seriously. So, for example, real scenario. I part of my law firm is a 2-bedroom apartment, and that's because I'm a workaholic. So sometimes I stay in my office. I have to attend the court virtually and that sort of thing to prepare for the next day, right? Is that a dwelling house? I can't tell you that. I don't know. So, and these things, now with new legislation, you have to wait for judicial interpretation, you know? And that's one of these things I was saying, if we can have a sunset clause, because this is brand new legislation. I don't know how many persons in Trinidad live in boats, but I know there's a big yacht club, you know? So a boat is covered by it, a vehicle is covered by it. We don't have those RVs, a big RV society, you know, but the definition in itself leaves for a lot of legal interpretation. Because even when it goes to the application of the act under section 5, Yes, it has to be the dwelling house, but you have to be in lawful possession of. That term possession has been subject to a lot of legal wrangling, because you could be in occupation but not in possession. You know, you could be a visitor, you could be a lawful visitor to a property, and you get some sort of rights, but they have used the term here, you have to be in lawful possession of the dwelling house. How do we interpret that? You know, so certainly, and interpret it in a context where this is criminal legislation, you know, because words in law have different meanings depending on the court you're in. So I might be in a constitutional court or in a civil court and talking about property and possession and adverse possession. The next person saying it's occupation as opposed to possession, and who in exclusive possession and that sort of thing. And then you go into the criminal arena and the word possession has a whole different meaning from possession in the other court. But the constitutional court is our highest court. So someone could very well strike this down for being too broad. Yes? Challenge it under the Constitution. So there's a lot of room for interpretation and misinterpretation because the definitions are not very clear.
Thank you. And if you would permit me, Councillor, we are taking some questions virtually as well too on our live. And there's a question that came from Denrick that I want to add and maybe put it towards you, Senior Counsel. And it's connected. The law says a man's home is his castle. But where does property end? We have renters, squatters, family disputes, border disputes. How do I know where my property begins and ends in situations like that?
Yeah, in order to get coverage under the Act, one would have to fall under the definition of occupant in Section 4. And the definition of occupant to cover owner, occupier, tenants, persons having management control, or anybody having a right at any particular time to be on the property. Right? I invite him to look at the definition of occupant in Section 4 of the bill.
Okay,
Yeah.
Thank you. Councillor? Alderman, sorry. My apologies.
On all established protocols, my name is Kobe Sandy from the great borough of Point Forte. And I came here to raise some concerns, particularly for Point Forte, because, of course, you know that our MP is now on the UNC side. And I really thought they would have had their meeting in Point Forte because I had some concerns. And they didn't, and I think I know why. In Point 14, most of the state land, where majority of the population resides, are divided into three major entities: Heritage, Rural Community Petroleum, PSAEL, which is part of the Cycle Authority, and the other one is Commission of State Lands. Where I am from, majority of the district is Heritage, Rural Petroleum land. And there is not really a delineation. People just build the place and say, this is my piece. And, you know, my neighbor, she has deceased now, we call her Rosie. And she, in her part, she had a china tree and a kaime tree. And the children in the area, myself included, used to love the child and the kaime tree. But she was a customer and she always used to tell me, get off she piece of land. She don't, you know, because she does sell the china and the kaime to the market. But we don't care, we go in and pick it, because all this land is beyond. And the kaime tree part had a confusion between her and my parents. So I used to go on about the kaime tree, of course, I used to eat it. So what I'm saying to say is that what is the problem then will arise if Rosie was alive today and see we picking she good kaime that we see this our kaime. I don't know if all of them Tom know what kaime it is, but we in South know what kaime it is. And we picking the kaime and they want to, and the Rosie want to attack us and say, you know, lawfully we are coming to property and we are denying her resources to sell and you know and so on. And she emptied the clip. on per week. And this is a we laughing now, but this is a big concern. Point 14. So that is one major concern I wanted to raise. And of course, other than that, that we have this group of interns for our government that has said that, marketed this bill as a panacea for crime reduction. Other than panic button and building wall and gates in community, this is their panacea. And the thing is that the man on the ground will not be reading this bill or understand this bill, but will understand what is being said by a Minister of Defense who can defend themselves, a Minister of Security, and the Prime Minister of herself. So this is what I'm saying, and I will hope that my MPs in the opposition raise very clearly that how they have marketed this bill is poor and is setting up population for chaos, confusion, and destruction. Thank you very much.
Thank you very much. Members? Yeah.
Well, I wonder whether Miss Rosie had green climate or purple climate. But the bill would cover Miss Rosie's land as being adjacent land used in association with her dwelling house. All right, so keep away from Miss Rosie Kaimitri and her Chenetry.
Okay. Yeah.
Nicole Young for the Spain North St. Anne's West. I'm asking this question because of the rumblings I've been hearing in my district of Belmont. Okay, so I am aware, I understand the concept of somebody coming into your home, a home invasion, and you take your cutlass, chop them. I get that. But what about setting booby traps? And I think that is something that maybe our legal minds could explain, because I understand, it's not that you were being chased, you're not running away and trying, or self-defense, you set your booby trap. Please give me some guidance on that.
So I'll start by saying that I have not seen that the bill discusses traps, but the Offences Against the People Act, which is an existing legislation for, decades, that discusses setting up, I think it's worded with the term spring traps, and there's another type of trap described there. And the legislation does contemplate in securing your home if you set a trap, whether it amounts to a defense, and it has to be done in a particular way, and there are parameters and all of that, and generally speaking, reasonableness and the I forget the word. What is it? Not proportionality, reasonableness and proportionality in everything. Right? There's a general test in law called the reasonability test. If your actions are reasonable and commensurate with the risk or the threat, what is the imminence of the threat, all of that. And in securing your premises, if you secured it in such a way that it causes a foreseeable and unreasonable threat to a wandering child, for example, you may very well find yourself in trouble. But to answer you directly in respect of this bill, I haven't seen that the bill addresses the setting of traps. But you may very well find that you are covered under other existing legislation. Thank you. Yeah, Farai?
I would strongly advise against setting the trap. One of the reasons being, obviously, when we look at clause 7.2 of the bill, when it speaks to when determining whether the offensive force used was reasonable in the circumstances, the court has certain things to take into consideration. And one of those things that they have to take into consideration is whether any party to the incident is a person with a mental disability under the Mental Health Act. And as I said before, Alzheimer's and dementia falls squarely under the Mental Health Act. So, that's a live situation. I believe in Tobago, recently an elderly man, he just did not know which house. So that's the nature of Alzheimer's, yeah? And his neighbor used a bit, well, I don't know how much force, but he killed him, yeah? He killed him. So if it is that you're planning in advance with your booby traps, and your booby traps are lethal, you might kill someone who's innocent, completely innocent, come onto your property by inadvertence. And then you will obviously be faced with some sort of, what level of manslaughter that is. But yeah, so counselor, don't do it.
Thank you. Thank you, Farah. So just before you go, I just want to field another question virtually as well too. This is coming from Kevin. And the question is, a person relies on the legislation, kills or seriously injures an intruder, and finds themselves charged and awaiting trial. What are the implications for them? 1, getting or retaining employment. 2, applying for or keeping a visa with a pending charge. And 3, the continued protection of the family if they are denied bail. I see the attorney shaking their heads. This sounds like a serious question. So 3 issues: employment, visa, and continued protection of family. All right. So I mean, the first question that arises is whether you get bail or not, right? So if you don't have bail, I think the answer is quite clear. There's limited protections available for your family if you were the defender of the family. Presumably, and I presume that because you are the one who are arrested for defending the family in the first place. So of course that comes with any arrest and the denial of bail. In respect of employment, it depends on the employer. So some employers will tolerate a pending matter showing on your criminal record. Others are not so tolerant. Some employers would, even without the criminal record, if they were to see in the newspaper or get wind of you running afoul of the law, being accused of running afoul of the law, they may take the view that your employment has to come to an end. And then, of course, you are left to investigate whether you have any legal recourse in respect of employment law for that. So that again is a sort of a contextual issue. In respect of visa, it is the same. It depends on the visa you apply for. Some embassies would require you to be of a particular character, as we refer to it in law, whether you have good character or not. Some will prevent you from getting a visa if you have a conviction. Others may prevent you from getting a visa if you have a pending matter. So that those are really the practicalities of it from my experience in criminal law. Thank you very much. Sir?
Good evening, everyone.
Good evening.
From Mount Lambert. I accent from Nigeria, but I've lived most of my life in Trinidad. Came here since 2015. So I've been here for almost 10 years now. First of all, I would say the laws of home invasion is not really a good idea. I've been a victim of home invasion too, some years back. And I would say the best way to sort that out is we should be talking more about police patrolling the community more often instead of the stand your ground law, because talking about stand your ground law, you encourage the people to go and get firearms to protect yourself. And it's not a nice thing because you're gonna spike up crime. And having people with firearms in a community, I've lived there enough to know that people are very emotional and very trigger happy, And I could tell you from my experience when I got invaded and they stole my TV, stole cash, it was just me and my father living alone. I was not home. And the first thing that came to mind was like, wish I was home. I would have chopped off somebody with a knife, killed somebody. That was what was going in my mind. So imagine if I was actually home, what would have happened to those people? I would have done it, but that was in my mind. So yeah, and then I have a question. Sometimes we have rift with our neighbors. We have fights with our neighbors, and then let's say 2 neighbors quarrel, and my neighbor quarrel with me, I'd have good fight with my neighbor. We don't speak. Someone down the line, something happened, probably the football in my yard or something, and the neighbor decide to come to my yard to pick it up. And then me now, see my neighbor now, it's like, okay, I feel threatened. I shoot the neighbor, and the neighbor dies. And the police come, pick me up, and we get to the station. And during an investigation, the police asked around in the neighborhood and found that me and that particular neighbor had a fight before. So am I gonna say that is self-defense, or then it becomes a case of premeditation? I plan to kill the neighbor. I was just looking for the opportunity to kill the neighbor.
Thank you. So firstly, Sule, I would like to ask you, especially on the issue of emotional reactions with adrenaline in a dangerous situation. Just a comment on that.
Well, I'll start first by saying I think he should consider running for Minister of Defense. So you're making some excellent points. I had some of those same considerations. My neighbor bananas growing over my fence. Is that a reason for me to, encroachment? Can I maneuver? I don't know. But yes, we are a society that we're not an emotionally mature people. All right. We are a people, and we have to own that. We are a people who live in our emotions in the moment. So when we having a good time, we having a real good time. There's no limit to the goodness of the time. When we vex in the moment, you're real vex. It's having control of what's going on in the moment when you're vex. As a matter of fact, I grew up, there was squatters behind me. That's the first time I heard a mother cuss her children about their mother. Right? And as a child, I was always thinking about, wait, you're cussing your children about their mother, not you. So when we get upset, we have these extreme mood swings that we live in the moment. And so as a people who are not emotionally, I'm not saying everybody, but on large, culturally, we're not emotionally mature. Is that a population that we want to arm, boy? Really? Do we first want to address the culture then of emotional maturity, about having emotional intelligence, what to do when you get upset, instead of come out your car and cuss and carry on and so on or whatever? How do we address that? When you are upset as a student, you don't climb on top of a desk and start to cuss teacher and everybody and pelting and go after officers and police officers and so on. We need to first address those things before we start talking about loading up mathematics and arming populations, right? Because then what you're going to do is to armor emotionally volatile people. Are we aiming to have school shootings and another set of issues and so on? Is that what are we aiming to potentially have a whole new set of issues to deal with on top of what we are already struggling with? So those are conversations that we need to have. Definitely.
Thank you. I don't know if anyone wishes to comment on some of the other issues. Okay, ma'am.
Yes. So I'm saying with this education that we have gotten, what do we do with it? Because the government has the numbers. We saw with the grandparents bill. Although the PNM objected to two other clauses they put in that had nothing to do with the original bill, I think it is passed, right? So what do we do with this information that we get with the numbers that they have? Because there's a SOE, so we can't protest. What do we do when we leave from here with this? What do we do so that we could get this bill passed or something like that? Because then we are kind of powerless in this situation. We get all this information, and then at the end of the day, the bill is passed because the government has the numbers. So what do we do? You end up in a situation where we're living fit for the psychologists. We're looking up our shoulders. We don't know how to de-escalate situation because it's standing ground. No obligation to retreat. Your perception, if you feel that you are threatened, you have the right to shoot. That is what they're telling us. There's no obligation to anything. So are we going to be living in a gun town where we feel threatened as a people of a certain ethnic group? I already spoke about sexual group, a group that has a different sexual orientation, or what do we do? I feel kind of scared and powerless because what am I going to do with this information? But when the government could basically pass this as is, what reports do we have if this is passed the way it is? I don't know if you're good.
Okay, thank you, ma'am.
Well, as Viash pointed out at the beginning, I mean, this is the first in a series of public consultations that will take place throughout the country. The thing about it, ma'am, is that the bill is presented as one that will require a constitutional majority in order for it to be a special majority in order for it to be passed. It means that the government will require the support of the independent senators in the Senate. So what we would hope is that as the consultations proceed throughout the country and persons come forward to express their concerns and or their support, the various contributions and the essence of them would make their way to the ears of the independent senators and help to inform their views as to whether this legislation is fit and proper for present-day Trinidad and Tobago. All right, so it's not a foregone conclusion, and we're not operating in futility at this present point in time.
Thank you, Senior Counsel.
Just further, I wanted to say that I think education also will be key, educating the populace, right? As somebody pointed out previously, Morton, I believe, pointed out previously, there's an overwhelming belief that this legislation came out of the need for populace legislation, right? Because persons may believe this is what the population wants to hear. Load up the matic and empower yourself and, you know, empty the clip on whoever comes into your space and so on and that sort of thing. But if with constant education of the population, I believe the population can find a voice through edification. And an educated population can make noise. And if they make enough noise, I don't want to speak to the government, but this current government has shown to sway to popular decisions, right? Some popular decisions. So if the population makes enough noise based on education, I feel as though the population might be able to sway the government in that regard.
Thank you, Sulesh. Sanjeev.
Just to add two quick things. One, you know, in respect of any legislation, whether new or existing, archaic, the court is always there to provide relief if legislation either becomes contrary to cultural orientation of society, if it becomes unjust. I'm talking about legislation that exists. And the same applies to new legislation. If it were that legislation, any legislation, I'm not saying necessarily this, but any legislation that were to come into law and be proclaimed, if it is found to be contravening generally society's interest, whether unconstitutional or not, the court can stand in the way of that, stand between the parliament and the people, as it were. But the other thing, ma'am, I would say is that we have an individual and collective duty to act responsibly under all circumstances. So that whether this legislation is carried or not, that duty remains upon us. It is incumbent on us, those who are in support of this bill and those who may be against it or may be against it in its current form and therefore wish to see it in a different way. We all still have that duty to one another. As I said, an individual and collective duty to act very responsibly under all of the circumstances, because it is in our best interest to ensure the longevity and the continued progress of this country. And in so doing, I would urge all of us in this country, in acting responsibly, there will come a time when we must vote responsibly, ma'am.
Thank you, Sanjeev. And ladies and gentlemen, this is certainly a very informative session, but of course, we are working with a time limit. So I see 3 people in line there, so we will take those 3 questions and we will look to conclude. Ma'am?
Good afternoon. Standing on the protocols established. My name is Aria Lidibity. I am from the constituency of Alabama. So I would have noted this evening that the change in this legislation to the common law is the degree of force is greater, with the term grossly disproportionate, right? Does this legislation, or is this legislation a risk to self-defense or expanding self-defense in that way? We know self-defense has to be reasonably proportionate. In other criminal cases as battery and so on, would this legislation expand the use of self-defense?
Yeah, what it does is introduce a different test. as to whether you acted in self-defense. The issue is whether you acted in a manner that is grossly disproportionate to the risk that you were facing. The problem, the concern is, it is going to create a lot of doubt in the minds of the police as to whether people should be charged or not charged. Because how do you really determine what is grossly disproportionate, separate and apart from what a jury would decide? The danger is that you can have the police exercising that discretion to charge or not charge in deciding whether you acted in a way that is grossly disproportionate, in a way that is not proportionate. In other words, the man in West Moorings might have a lesser chance of getting charged than the man in Toko, right? Because the bias of the police is going to come into play in deciding whether they believe that what you did was grossly disproportionate or not. So that is the problem with the changing of that test. And the question is it really necessary to go there? All right, that is something that we would have to grapple with as we move along.
Okay, thank you.
Pleasant evening, everyone. I am Kim Garcia-John, representing the law, and I would like to just say that today is something I said at work today, that having information allows one to make well-informed decisions. And I have to really thank the panel and the opposition leader for giving us this opportunity to be educated. All right, and my plan ending will be my beginning in that someone asked, what do we do? What then? So I would like to suggest that I know that I would do it. I would go to my family first and foremost, go to the community, the constituencies, the party groups, and let them know the truth so that we will not be fooled, and shrouded by these codes. All right, this is just that was supposed to have been my ending. But my question is the judicial lines. And I just wanted to say, all of these things through the discussion. And how do you see the balance being struck between individuals' right to defend themselves to enforce this balance fairly? And if so, depending on your response, what should be in place? So what consideration should be given? Thank you.
Thank you very much. Sanjeev?
Yes. All right. So, I mean, look, I am an attorney at law, and I will express, without fear of criticism, that I have every faith in the judiciary of the Republic of Trinidad and Tobago. But I have not had the experience of having to cast a shadow of a doubt on the integrity of the judiciary. And so, I mean, I leave it. I continue to trust the judiciary in applying any legislation that is passed. I think really the question is one of messaging. I did mention earlier that where legislation is in place or is enacted, new legislation, at any time where a citizen feels deprived of any rights, the court is there to stand in protection of that citizen, to hear their plight, to hear the arguments, and to make a decision. And we've seen it in the not too recent past. I wouldn't go into the particular legislation, but we've seen where legislation has been, long-standing legislation, has been struck down for being found to be unconstitutional after being in effect for decades. So that I will place my faith in the judiciary, and I have no difficulty there.
Thank you, Sanjeev. Farai?
I don't practice in the criminal court, but just as everyone would know, I think the criminal justice system is a struggling justice system. The nature of this legislation, you'll have to educate the masters, you'll have to educate the magistrates, you'll have to educate the judges who have to interact with this legislation because it's new legislation to our jurisdiction. So it calls for a lot of judicial training. It calls for a lot of things to be put in place because even if we have a criminal justice system now that is struggling even with the common law situation. So you add to the common law statutory situation, you're adding to the workload of the judicial officers. So that's something that has to be consulted on. The Chief Justice was consulted on this legislation because it will have an impact. We can't be naive about it. New legislation, new criminal legislation will have an impact in terms of the judges because they have a discretion, and certainly bright attorneys or half bright attorneys will challenge your discretion. So it brings more on the plate for the judicial office. So I'm happy to the audience has been edified, and certainly I'm happy to be a part of this panel. And certainly I could only speak on my behalf, and I could probably speak on behalf of Sule because I'm learning since 12. We went to high school together. But we will assist the party in terms of educating our members and educating the citizens of Trinidad and Tobago so that they understand that the legislation is not the propaganda being spoken. Yes? What you read in black and white is diametrically opposed to what you hear on the political platform. So certainly what you get at a PNM consultation is sober confidence. So I hope that collectively we would have added value to your evenings, because I know you all could have been anywhere with your families this evening. But certainly take it back to your party groups. Take it back to your party groups. I'm seeing Eric in the crowd, a field officer of the movement. We need to take it back to the grassroots, take it back to our members and let them spread it. Let the conversation spread. Because even if you can't protest through a state of emergency, you could still have a conversation. You could have your cottage meeting. We need to get back to the ground. And that's generally for the party, and we get back to the ground by having these consultations, listening to y'all, because y'all gave us more than we gave you. Just as how you are saying thank you, I'm saying thank you. Because I heard a lot, especially from Alana, an unfortunate situation, but she did suggest a situation there, put in a compensation clause. People shouldn't suffer twice. Yes? So, and that is what a consultation is about. It's more about listening. And when we listen, certainly the parliamentarians are here today, they will be well equipped in the debates in Parliament to persuade any independent senator to see it out. Huh?
Thank you, Farai, and certainly a lot of valuable information.
Can I say quickly, please?
Sure, Sule.
One of the things that I have noticed is we do the assessment for FULs, the psychological psychometric testing for the FULs. And there's been an increase in demand, persons wanting to come for psychometric testing for FULs, right? To get it done. I didn't say that. But there's been an increase in demand of persons wanting the FUL. And one thing that I noted this week actually was that some of the previous assessments persons did, or letters that they would have received, they were told, they needed an update. And some of the previous work that they would have done to me would not have met what would have been best practice for the assessment. So you sit down with somebody, you talk, and they probably tell you, yeah, you sound like somebody who ain't gonna shoot nobody. Let me give a recommendation. What I am hoping, or what I was hoping to find out of this was to make the process more robust, right? I think that's what I was hoping when we have this conversation about standing ground. Perhaps we should look at the system that we already have and how do we fix that system? Now, because as a layman, I look through the home invasion because it's really not standing around as the Honorable Mayor mentioned. And I didn't see anything about firearm in it. It's stand your ground. So if you have a bat, a cutlass, or whatever, it's stand your ground. At least that's what I get as a layman. My concern is that it does not fix the process of everybody who applies. So maybe you might be deserving of a firearm, but it doesn't fix the process. You may have put in your request 10 years ago and you're still waiting, right? It doesn't address the process. And so I have some concerns with addressing the process. The systems that we have now, let's address that process. Let's, I think a gentleman came up earlier and he provided some suggestions as to how we can make the system more robust and so on. But those type of conversations, how do we fix what we have first before we start talking about stand up and open your matic and empty the clip on them? Yeah.
Thank you, Sule. And before we close off, we have room for one more question. And in the process, I will allow Sanjeev and Larry to make some closing remarks.
Hi, good evening. F4 Allen, Port of Spain North. Or more of information. So what is the preparation that goes into including some of the comments and questions people had? And I'm sure these are not future questions. They're not even today questions. They're yesterday's question. So how was that taken into
to fix in a way that the present law does not address? And that is something when the legislation is presented in the Parliament, because certainly we are all entitled to know why
Sanjeev, do you care to comment and also make some closing remarks?
I would take the opportunity to make some closing remarks at this time. I mean, I share the sentiments of my fellow panelists, but more importantly, use the people that have taken the evening to come and spend with us, share your thoughts and ask questions, and more importantly, give suggestions and make comments. I'm sincerely grateful for this opportunity. I look forward to the other consultations that come up, whether I am a panelist or not. In fact, I have questions of my own that I would like to address to our panel. And so I hope I'm given the opportunity to sit in the audience. But, you know, friends, I think that my real sentiment on this is crime and criminality are two different things, But there are two real things that we face in society. We've had this trouble before. We've seen this movie before. It is a continuing problem. And my suspicion is unless we address the root causes of crime, as the political leader spoke about, unless we address the root causes of crime, these types of things aren't going to solve the problem. That is my position and my views. And with that being said, I will personally support any measures that aim to address crime, as long as it is, just like this bill, reasonable and proportionate and equitable and in the interest of all of the people of Trinidad and Tobago and in the interest of nation building. So thank you.
Thank you very much, Sanjeev. And ladies and gentlemen, as we come to the conclusion of this national consultation on Stand Your Ground legislation, in fact, the first that we have had here, hosted by the People's National Movement, allow me to take the time to thank you all, members of the audience and members of the viewing and listening audience nationally. Thank you all very much for participating and for, most of all, sharing your views with us. Can you please give yourselves a round of applause because you did excellent. I'm very certain with the leadership of the party that's here, the party officers, the political leader I saw taking very copious notes. I think, rest assured, your views would not fall on deaf ears. I would like to thank the panel here, Farai Hove Masaisai, Sule Joseph, Sanjeev Budu, and Larry Lala SC. Can we please give them a round of applause, ladies and gentlemen? Thank you, panel. You did an excellent job, I think, in bringing clarity, some clarity, because I know there's a lot more clarity to be had. We thank the People's National Movement for taking the initiative for hosting this national consultation. And as the political leader would have indicated, this is the first of many, and we look forward to the other consultations. So we thank the People's National Movement. We thank the party leadership and the political leader for having this foresight and vision. And lastly, we thank everyone for taking the opportunity who would have participated and been part of putting this national consultation together. And with that, ladies and gentlemen, I conclude this national consultation, this first national consultation hosted by the PNM, and I wish you all safe travels home. Thank you.
Somebody give me a rhythm to activate the waistline on the feminine gender. No, please.